Be seated. Be seated. Thank you. All right, let's open the record in case number 0905-9264-FC, the matter of People of the State versus Thomas Foley. This matter is set today for further proceedings following jury verdict. Initially, it would be my intention to handle the motions that have been filed. The defense has filed essentially two motions, which are in many ways interrelated and combined. But Mr. Schaefer, do you wish to be heard?
I do, Your Honor. Your Honor, the first motion that I wish to address is the motion for directed verdict of acquittal. I have set forth in written form that motion along with a supporting memorandum. And the information is there for Your Honor to consider. And the trial took place for over a 3-week period and in close proximity to today's date, so I think it's probably fresh in everybody's mind. Pursuant to MCR 6.419, this motion has been brought. I'll be the first to admit that this is not a common thing that is granted. In 38 years, I don't think I've ever had one granted. And perhaps in your judgeship, you have not granted one. But it is the law that exists in the state of Michigan, and it is there for a purpose. Our system, as good as it is imperfect. And sometimes it's imperfect to a point that there has to be a safeguard. And the safeguard in this particular case is this remedy of a directed verdict. The standard as set forth in the law and in the memorandum is that, according to the Lemon case, that if the evidence preponderates heavily against the verdict, so it would be a miscarriage of justice to allow the verdict to stand, then a directed verdict of acquittal should be granted. As argued in the memorandum and as set forth over 21 paragraphs of evidence that I suggest not only point to innocence but points to not guilty beyond a reasonable doubt, which is the standard that must be adhered to by the jury in this particular matter. If, in fact, the jury did not apply the evidence accurately and correctly to the standard of beyond a reasonable doubt, then I believe that that is the trigger for the court to grant a verdict of acquittal. To allow a jury to disregard the proper application of evidence that was presented to the proper standard of guilt beyond a reasonable doubt is an improper carrying out of the duty of the jury, and pursuant to the case law allows that to be reviewed under this motion. We are asking that Your Honor review the evidence that was presented. We're asking specifically the 21 points that were brought out in the memorandum indicating evidence that I submit determined that the defendant was not proven guilty beyond a reasonable doubt. And in order for the jury to have come to the decision that they did, they had to have disregarded, I submit, all of those items, which I don't believe is a reasonable application of the evidence. especially when much of it was unrefuted. Your Honor, I have set forth in the memorandum and the motion the position of the defendant in this regard, and I would respectfully ask the Court to take the proper position under the law to review the verdict that the jury determined based on the evidence that was given. I'm not suggesting this is something that is done often. It cannot be done lightly, but it is a provision in the law that exists and is available to be a safeguard against an extreme imperfection of the system that has gone forward. And I would ask at this point in time that a verdict, directed verdict of acquittal be entered. Thank you. Do you want to deal with both of them at the same time, or?
No, let's deal with them singly.
All right.
All right, do the people wish to be heard as to that motion?
Yes, Your Honor, please. Your Honor, a review of the defendant's memorandum of law certainly shows that he's listed all of his arguments that he made at the time of the trial. But the jury deliberated for an extensive amount of time, and they chose to reject those arguments. That's what he's listed. Now, the jury's verdict isn't contrary to the great weight of the evidence, Your Honor. There was no overwhelming evidence against the verdict. There was no miscarriage of justice in this case. The case law is pretty clear that there must be a real concern that an innocent person's been convicted, and we don't believe that that's the case here. The testimony does not contradict the facts of the law. Now, the case law in People v. Stiller makes it clear that where the evidence is nearly balanced or such that different minds could come to different conclusions, the judge may not disturb the finding of the jury. So even if this Court were to find that to be the case law would prevent that from occurring. But we believe that that is not the case. The people submit that there was sufficient evidence to bind this case over to the Circuit Court, that there was sufficient evidence to survive a motion to quash the bind over, and most importantly, that there was enough evidence to survive a motion for directed verdict at the trial. The people presented sufficient evidence for the jury to find the defendant guilty beyond a reasonable doubt. We believe that, as we have outlined within our memorandum of law, there were a number of points made, but certainly the Court was here and they heard all of the evidence as well. And we would ask that the Court deny the motion.
May I respond briefly?
You may.
I believe that the points were listed are not the arguments. The points listed, I think, are the evidence that was presented. And the standard is that the great weight of evidence is such that the verdict should not stand. And as a result, I think the motion is a proper motion, and I think it is supported by the evidence that was presented. I think the prosecutor is correct that the standard and the purpose of this is that the system is such that an innocent person should not be subject to the miscarriage of justice in a circumstance when the evidence is overwhelming. And I submit that it is, and I would renew my motion.
Well, the motion is properly brought pursuant to court rule and the law. As is recognized, the jury's verdict is entitled to